Christina Ciders is a grandmother and a mother. She's a wife, and she wants out of jail. Christina Ciders is accused of abusing 16 of her grandchildren by allowing them to live in conditions in a home in Vinton County, Ohio, that the sheriff said weren't fit for livestock. The children who were removed from the home, according to the prosecutor, suffered serious physical harm. The nature of the...
On June 30th, 2026,
law enforcement arrived at defendant's home with the purpose of serving another member of defendant's household with an arrest warrant for unrelated misdemeanor charges. Nonetheless, defendant was detained and arrested outside her home. That is the official account from a motion filed in Vinton County, Ohio. What those dry sentences describe is the moment a 66-year-old grandmother was pulled into a case the sheriff himself declared involved conditions not fit for livestock. Before we go deeper into what the documents actually show, make sure you're subscribed to Trial Theory Unsealed, because we don't just cover the story. We follow the evidence. Imagine a house where the floor itself becomes a document, not hardwood or carpet, a layered archive of neglect so thick that every step tells investigators something. That is the visual the state wants seared into the public mind. 16 children removed, 16 charges of child endangering, each a second-degree felony. Therapeutic foster care required for all of them, not standard foster care. Homes with caregivers specially trained for children carrying deep emotional and behavioral wounds. County scrambling to find 16 beds in a system already stretched to breaking,
including an 18-year-old, are in therapeutic foster care. Therapeutic foster care, it's different from traditional foster care. The caregivers are specially trained to help children who may have emotional or behavioral issues. The county had to find families to take in all 16 children. Let that sink in. Christina faces those child endangering charges, and so does her husband, Gary Ciders Sr. Their son, Gary Jr., and his wife, Elizabeth Ciders, they face the same charges for their 16 children. All four.
Then the defense drops a single sentence into the court record that lands like a detonation. The weight of the evidence against defendant is minimal. Minimal word now sits inside a publicly filed motion attributed to attorney Kendra Roberts of the Ohio Public Defender's Office. She argues that the state has produced nothing. No documentation, no witness statement, physical proof that Christina Ciders committed any act of abuse against any of her 16 grandchildren. The prosecution's entire case, according to the motion, rests on one fact and one fact only: she was present in the home on Omar Street on June 30th.
Christina Ciders' lawyer also questions the weight of the evidence against her. The state has charged defendant with endangering children, which would require evidence that on or about June 30th, 2026, defendant did abuse each of her 16 grandchildren, and that she caused serious physical harm to every one of the children. To date, the defense has received scant evidence suggesting defendant committed any of the alleged offenses. The weight of the evidence against defendant is minimal. In fact, to date, there is no evidence that has been provided which would support the finding that defendant committed any acts of abuse, let alone that any of the children suffered serious physical harm because of abuse by defendant. To date, the state has presented evidence only that defendant resided and was present in the home on June 30th, 2026, and that the conditions of the home were unsanitary to the extent that the removal of the children from the custody of their parents was deemed necessary by authorities. Christina Ciders' attorney says she has no prior criminal record, and while she can't return to the home on Omar Street, she has a place to stay if she's granted bail. Roberts wrote, "Defendant has strong family support. In fact, in release, defendant will reside with close family members."
Presence. Let that word hang in the air for a moment, because this is where the legal architecture of this case begins to fracture. The state says the home was a crime scene. Defense says residing in a crime scene does not make you a criminal. That is the fault line. fault line runs directly under the feet of a woman who has now spent weeks inside the same jail where actual violent offenders await trial.
He was given a signature bond today. Well, the only place she has to go is back to the house where these children were held. I don't know what other family, when they talk about family support, I don't know what other family they have. That wasn't indicated. But besides her husband, who himself is being examined for competency, and the children, which are in the custody of adult or children protective services, what family would she go to? Where would she live? Those are, I think, important questions.
Here is a phrase you are going to hear 3 times. The accusation is not the evidence. Repeat that. The accusation is not the evidence.
So, it sounds like she's just arguing like, look, this wasn't my client's problem. She's just letting these people live in her house.
I think that's exactly setting up a defense, number one. But number two, probably true. She's 66 years old. They are the younger members of the family's children. And I don't know what her mental state is from the looks of her husband and the statements by her husband's lawyer. It sounds like he may have more problems than she did in trying to live day to day and address issues. But it's just, I think, setting up the defense, but it also.
Because what the defense filings reveal is a prosecution still under construction. There is no grand jury indictment. Not yet. All 4 defendants waived their right to a preliminary hearing, the very proceeding designed to force prosecutors to publicly lay out probable cause. Why would an innocent person waive that right? Or more precisely, why would a defense attorney advise 4 separate clients to do so? Perhaps because they know the evidence is so threadbare that the spectacle of a preliminary hearing would only expose the prosecution's hand, or lack of one. Manner in which the search warrant documents were sealed is now being challenged at the Ohio Supreme Court. Think about that. State Supreme Court is being asked to rule on whether the very paper that authorized this search can remain hidden from public view. The accusation is not the evidence. We arrive at the competency motions. 3 of the 4 defendants, including Christina Ciders, have now requested psychological evaluations. The statute is clear. Can the defendant understand the nature of the charges, and can she assist in her own defense? The motion is bare-boned.
Keep in mind, each defendant has waived his or her right to a preliminary hearing, which would have required prosecutors to present evidence to show there was probable cause that each of them had committed a crime. The case hasn't even gone to a grand jury that we know of. Now, Christina Ciders' lawyer, she's not just asking for her client to be released on bail. She also wants her competency to stand trial evaluated. Attorneys for Gary Jr. and Gary Sr. have also made that request. Roberts wrote, defendant, by and through counsel and pursuant to a revised code, hereby raises the issue of her competence to stand trial. Counsel has reason to believe that defendant is unable to fully comprehend the proceedings in this court and is unable to assist counsel in the preparation and defense of this case. Defendant moves this court to order that defendant undergo a competency evaluation to determine if defendant has the capacity to stand trial, and upon receipt of.
Former prosecutor who reviewed the filings noted something chilling. Psychologists' first exam will likely happen inside the county jail unless the judge grants bail first, which means the state's own mental health evaluator may end up assessing a woman whose competency may be deteriorating precisely because she remains locked in a cell awaiting charges a grand jury hasn't even seen. This is where the moral architecture of bail collapses. The Ohio Constitution was amended in 2022 to allow judges to consider public safety. But public safety from whom? 66-year-old woman with no criminal record, lifelong roots in southeastern Ohio, no passport, no resources, and an offer to wear a GPS monitor 24 hours a day. Her attorney argues every factor: risk of flight, threat to the community, ability to pay, weighs in her favor.
The attorney for Christina Ciders also said that her client has cooperated with this investigation. She said she was interrogated for hours at the sheriff's office on the day that they were arrested without counsel present. So what does that say to you? I mean, she is dropping these nuggets for the judge to say, look, my client's not a threat to anybody, not a threat to the public. She's not a flight risk. You know, she's 66 years old. She doesn't have a prior criminal record. She's been cooperative. Is all of this just to show, it sounds like she's just arguing like, look, this wasn't.
The state has not yet filed a response.
Let's move on now to the issue of bail. Right now, Christina, Gary Jr., and Elizabeth, they're all being held on a $300,000 bond. We know they can't post this. We get it. We know. So she wants her client released on bail. She said she has supportive family members who would make sure she gets to court appearances, etc. How likely is this to be granted, a reduction in bail? Because we don't even have a grand jury.
Meanwhile, Children's Services is already moving for permanent custody. All 16 children tells you the state is playing a long game entirely separate from the criminal proceedings. A parallel track where the burden of proof is lower, the timelines faster, the consequences irreversible.
Children's Services, they're going to be seeking permanent custody of these children. The county prosecutor told the county commissioners that just in the last couple of weeks. I mean, that was before this week. It was like 2 weeks ago. That early on, what does that tell you if they're seeking permanent custody that early on?
Well, they would have to have a hearing before the juvenile probate judge there in Vinton County. They would have to file an abuse, neglect, dependency kind of charge, which is a separate kind of administrative proceeding in front of the juvenile court judge to make that determination whether the children are at risk, that's the allegation, and whether the custody of the children should not be with these parents or grandparents who had such neglectful conduct over a period of time. So it tells you that they think they have a strong case, number one, and it also tells you that they're willing to go forward at
two legal systems moving at two different speeds toward the same family. The accusation is not the evidence, so we are left with a grandmother demanding release, a sheriff who described conditions unfit for livestock, a prosecutor who hasn't shown his cards, and a sealed envelope sitting in the Ohio Supreme Court that may tell us what this was really about, and whether the state kicked down a door before it knew exactly what it was looking for.
Have a family members with 16 kids living in your home, and they go in and they find feces and trash all over the floor, and it's disgusting, as the prosecutors and the sheriff's office have said. What responsibility do you still have as the grandmother to ensure that these children are living in a safe environment?
Well, at least that question is, I think certainly grandma has that kind of responsibility, but is it a legal responsibility? If you fail to meet it, are you subject to prosecution for endangering children? And at least I think because of the relationship, say she was just a landlord and was letting friends live there for several hundred a month, it might be a different situation. But since she's a grandmother of the children, I think that she would meet that minimal risk.
Go to the Vinton County Clerk of Court's website. Pull the docket for case number you will find linked in the description below. Read the motion to modify bail yourself. Every page, every line. Then answer one question in the comments: does presence equal guilt? Or is that the entire case the state hasn't yet proven?
Now, all three defendants, Christina, Gary Jr., and Elizabeth, remain in jail on that $300,000 bond. Prosecutors have not responded to these motions filed by Elizabeth's attorney and Christina's attorney to modify their bail. So when they do, we'll let you know what they say. You can read all of the records related to the Ciders case. We have the entire case file on our app, Law and Crime Plus. Check it out. And that's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much for being with me. I'll see you back here next.
If this kind of document-driven analysis is what you come here for, like this video, share it with someone who still thinks a headline is the same thing as a verdict. Subscribe to Trial Theory Unsealed and turn on notifications. We read the filing so the public record does not gather dust.